I'd like to talk to you today about a very interesting tax case involving benefits in kind. It's a case that was heard in the autumn by the First Tier Tribunal, and it's called Baylis, B-A-Y-L-I-S, and HMRC. It's to do with a benefit in kind problem that, interestingly, despite the fact the legislation we're going to be talking about has been up and running for 41 years, apparently has never actually had to be considered by the courts in all that time. We're concerned with a company. It's a company called Val Wyatt Marine Limited, and the company runs, from the sound of it, a quite upmarket marina business on the Thames, in the sort of Maidenhead area. And the taxpayer is a lady called Sarah Baylis. She had worked for the company for a number of years, and basically it was her dad's company. Mr. Baylis was the managing director and the controlling shareholder, and reading a bit between the lines was a bit of an autocrat, but both he and his daughter, Sarah, worked for the company in question. And the problem related to Sarah's mother, so Mr. Baylis's wife. She was elderly and ill, and she needed to go into a care home. And so Sarah booked her into a local care home called Harwood. I've been on the website, and I have to say it looks a pretty smart upmarket place, somewhere halfway between Marlow and Henley, I guess probably again on the banks of the Thames. Looks to be a lovely house with lots of care and attention given to the patients, and one suspects, therefore, appropriate monthly care home fees. This was originally in 2009. I've no idea what the weekly care home fees were, but in today's money we'd probably be looking at sort of £2,000 a week upwards. So it was sort of seriously upmarket place. And obviously when Sarah booked her mother in, she said that the company will be responsible for the care home fees. Mother was in the care home for nearly 2 years, and then sadly she died. What happened was that in due course, HMRC imposed a benefit in kind charge on Sarah because, as you know, although the mother wasn't an employee of the company, it is possible for benefit in kind tax to be paid if a benefit is provided not for yourself, but for a member of your family or household. And clearly Sarah's mother fitted that particular bill. The relevant legislation that we're looking at is found in section 721 of ITEPA. And you'll see coming up on your screens the details that are listed in section 721, subsections 4 and 5 of ITEPA, as to those parties who are considered to be a member of an employee's family or household. As you can see, it lists 6 categories: that person's spouse or civil partner, that person's children and their spouses or civil partners, that person's parents, that person's dependents, so I guess that would be someone like perhaps a brother who's fallen on hard times and who is financially dependent on the person concerned, a person's domestic staff, so unrelated parties who work for them, and finally, but I would imagine in practice pretty unusually, that person's guests. So there's a list, as I say, of 6 different categories of people who count as a member of your family or household. And as I mentioned, in due course, HMRC raised a discovery assessment on Sarah that her mother's care home fees represented a taxable benefit in kind on Sarah. Sarah appealed against these assessments, and I would guess perhaps one of the reasons why she would have appealed was because, as I've mentioned, the care home fees were likely to be extremely upmarket. If we took, for example, £1,500 a week, which is a not unreasonable figure that they might have been, we'd be looking at £78,000 of benefit in kind in a full year. Tax on that could well have been more than Sarah's net salary from the family company. So you can well see why she was not very keen on having her mother's benefit in kind imposed on her. More germane to the point that she had sadly also recently fallen out with her father, and she no doubt felt that her father, as managing director and controlling shareholder of the family business, was a much more appropriate person to be allocated the benefit in kind tax charge. So that's what this case is all about. Was the benefit in kind taxable on Sarah, or was it taxable on her dad? When the case was heard by the First Tier Tribunal last autumn, that's something like October 2016, the tribunal judge, who's a well-known lady called Anne Redston, made a number of findings. She agreed that when Sarah's mother entered the care home in 2009, it was indeed Sarah who had signed the contract on behalf of the company, and that was why the company, Val Wyatt Marine Limited, was the one that was paying the care home fees for the next couple of years. But she had contracted with Harwood simply as an agent for the company. Secondly, Anne Redston, the judge, found that where two employees are potentially liable for tax on the same benefit, it is not down to the employer simply to decide who pays. Again, reading between the lines, it may well have been the case that Mr. Baylis had simply said, well, in those circumstances, daughter Sarah was the one who contracted, she's the one who gets the benefit in kind. I have to say in passing, I'm slightly surprised that HMRC went for the daughter. In my experience, if the revenue have got the choice of, let's say, two possible people who work for a company to be allocated a benefit in kind under the member of a person's family or household rules, I would guess that 9 times out of 10, if not more, they would almost invariably go for the person with the higher marginal tax rate and tax band. There is no doubt in the Baylis case that the father, as a managing director and controlling shareholder of the family company, was in a higher tax bracket than his daughter. And I would have expected the revenue to have gone for the father first up in those circumstances. But they didn't, and I suppose it may well be that they simply took the view that because Sarah was one who had booked her mother in, that she was the appropriate person to suffer tax on the benefit in kind charge. But basically Anne Redston said it is not up to the company to decide. We have to look at proper legal principles. We then come to the most interesting part of the judgment, because although there is nothing specific in the legislation that gives authority for this, it was argued that Section 721 of ITEPA sets out a hierarchy. You may remember when I referred earlier to the 6 categories of people who comprise a member of someone's family or household. I read the list that is spouse, children, parents, dependents, domestic staff, finally guests. And what Anne Redstone was saying was that actually that represents a pecking order. In other words, you go for the person at the top of the list. If you can't fit them in, you move down a notch, and so on and so on. Now, if we go to the top of the list here, it is the person's spouse. So elderly Mrs. Baylis's spouse was, of course, her husband. So he came top of the list, and it was a notch above children, which was Sarah, and so it was held that the benefit was taxable on Mr. Baylis and not on Sarah personally. Now, the interesting thing is that there are parts of the benefit in kind tax code where the legislation specifies that if there are 2 or more potential people who can be liable for the tax on the benefit in kind, how it's to be determined. One example can be found in Section 169 of ITEPA, which operates in conjunction with company cars, where a company car is available for a member of staff and is also available in the same tax year for another member of their family or household. and it specifies how you determine who pays what. With other benefit in kind provisions, there is sometimes what we might call a just and reasonable determinant. But in the context of this particular rule, which is found in section 201 of ITEPA, there is no specific provision. So that is why the First Tier Tribunal resorted to interpreting the definition of family or household as being a hierarchy with spouse ranked at the top and guest at the bottom. That was the decision of the First Tier Tribunal. If it is unchallenged by the revenue, and I see no reason why it should be, then although it won't resolve all similar problems, nevertheless it will sort out this particular difficulty. As I've said, it won't sort out all similar problems because even if you go by the hierarchical rule, suppose you have the situation where, for example, two siblings are both employees of the same company. How would you determine between, let's say, a brother and a sister in those circumstances when they're both at the same level? But as I've said in the notes which accompany this talk, that will no doubt be a matter for another day. Thank you for listening to this talk. My name is Robert Jamieson.